Okay, let's unpack this. Imagine you've just had an offer accepted on a significant commercial property. Could be anything, an apartment building you're planning to fix up, maybe a busy retail center or a huge warehouse, right, for your logistics chain.
Yeah.
And there's that initial feeling, that wave of accomplishment, like, okay, the deal's happening.
Well, you think the hard part's over.
Exactly. But then, boom, the real intensity kicks in and the clock starts ticking really loudly sometimes on this incredibly critical period.
Yeah.
This is where you, the buyer, you get this like unfettered right to pull back every curtain, look at every single document, inspect every little corner of what you're about to pour millions into.
It's your window, your only real chance, usually.
It really is. It's your limited time to figure out if this property actually is the strategic asset you think it is. Or is it hiding some really costly secrets, hidden liabilities, or, fundamental flaws that could just completely derail your plans or tank your returns?
Yeah, absolutely. Because if you don't do that homework, do it thoroughly, and do it quickly enough in that window,
You could end up with something totally unexpected.
a pig in a poke, like they say. And the cost isn't just the purchase price. It's everything that comes after.
Which could be way, way more. And the thing is, right now, for a lot of buyers in today's market, that critical clock, it seems to be moving faster and faster.
That ticking clock feeling, that's spot on. It is absolutely the most critical phase in a commercial real estate deal. That precise window, right after the offer is accepted, but before it all becomes final and, crucially, non-refundable.
Non-refundable, that's the key word.
It is. And during this time, every single aspect of that property, the physical structure, the financials, the legal side, it all goes under this really intense microscope.
Right. So that intense period, that essential investigation phase, that's what we're really diving deep into today. The due diligence period in U.S. commercial real estate. We're going to break down why it's not just, important, but why it's truly non-negotiable for any serious buyer. And we'll explore the significant tensions and pressures that are really swirling around how long it takes, the practicalities of doing it.
And how those pressures are actually squeezing the time buyers have to do it right.
Exactly.
So our mission here for this deep dive is really to walk you through understanding the core purpose of this period. Why does it exist? What do buyers absolutely have to achieve during this time?
Okay.
We'll get into some key legal points, like what does selling a property as is really mean in the commercial world? And maybe more importantly, what are its limits? What disclosure duties do sellers still have?
That's a big one.
Huge. And we'll talk about the market forces, the external stuff that's pushing sellers to demand shorter and shorter timelines right now.
Yeah.
That puts massive pressure on buyers. We'll look at the real-world practical challenges buyers run into, trying to do thorough checks in these tight windows. And then we'll touch on how technology is kind of aiming to shake things up, maybe transform this critical phase, and offer ways to deal with these pressures. We're drawing on a whole bunch of sources you've pulled together for this.
All right, let's jump right in. At its core, what is due diligence in this context? Why is it so fundamental for a buyer?
Okay, fundamentally, due diligence in commercial real estate, it's about the necessary care, the investigation, the activity a buyer undertakes. Basically, to get objective, reliable, solid information about a property before they're legally locked in to buy it.
So doing your homework.
Exactly. It's the essential process of doing your homework, verifying the facts and assumptions that your whole investment decision is based on. You're moving away from just trusting the seller's glossy brochures and what they tell you,
right,
to having your own documented understanding of the property's real condition, its status, its potential, its problems.
Okay, so it's the buyer taking the reins, verifying it all themselves. What are the main goals driving this? What's the buyer trying to achieve?
Well, the buyer's got several really critical objectives here. The absolute most fundamental one, as one source put it, is simple. Avoid buying that pig in a poke.
Right. Don't buy something sight unseen, essentially.
Exactly. You just don't want to commit, potentially millions, maybe tens or hundreds of millions of dollars without knowing precisely what you're getting into, including any hidden problems or liabilities that could bite you later.
Makes sense.
Second, it's about gaining comfort. Based on the real information you dig up, you need to justify and really confirm that the price you offered is actually fair and reasonable. Considering the property's actual condition, its real financial performance, its true future potential.
So if you find issues, maybe the price isn't right anymore.
Precisely. If you discover, say, the roof needs replacing sooner than expected, or the income isn't quite what was advertised, that might mean the property's worth less, or it's going to cost you a lot more in unexpected repairs right away.
Okay. And the third reason?
Third, it's to rigorously confirm that the property lines up with what you understood going in. You need to make sure that what the seller represented about the income, the expenses, the condition, whatever, actually matches reality.
Verifying their claims.
Yes. And critically, if you have a specific plan for using the property, say you want to convert it to a different use, you absolutely need to verify that the zoning and other regulations actually allow that. You can't just assume.
That makes perfect sense. You see the nice pictures, the optimistic financial projections, but due diligence is when you send in your own team to, really kick the tires, look behind the drywall, audit the actual books. So what exactly gets looked at? The scope sounds huge.
It is. It's incredibly broad and multifaceted. Basically, the scope covers almost anything that could impact the property's value, its usability, or your future liability as the owner. A huge piece, maybe the most obvious, is the physical condition.
The building itself.
Right. This means hiring qualified inspectors, engineers. They'll examine the structural integrity, the foundation, the walls, the roof. They'll look at the HVAC systems, the plumbing, electrical, elevators if there are any, parking lots, basically all the physical parts.
And they write up a report.
Yeah, they prepare what's usually called a property condition report, or PCR. It details any visible defects, repairs that are needed now, estimates for future capital expenses like when the roof might need replacing, and the expected lifespan of major systems like the heating and cooling. This isn't just like a quick home inspection. It's often a very detailed engineering assessment, sometimes needing multiple specialists.
Okay, so the physical structure, that's clear, but there's a massive legal and regulatory side too, right? That sounds complicated.
Oh, absolutely critical, and often way more complex than the physical side. You're diving deep into the legal and compliance aspects. This starts with verifying zoning and land use regulations. You have to make sure your intended use for the property is actually permitted by the city or county.
Can't just assume you can put a shop there if it's zoned residential.
Exactly. Then, a huge one is environmental compliance. This usually kicks off with ordering what's called a Phase I Environmental Site Assessment, or ESA.
Phase I, what does that involve? Do they drill holes?
Not usually in Phase I, unless something specific pops up. A Phase I is more like detective work. It's a review of the property's history. What was it used for before? Were there factories nearby? Gas stations. They do site visits, interview people, check regulatory databases for things like reported spills, old underground storage tanks, or past industrial activities. They're looking for what are called RECs, recognized environmental conditions.
Yeah.
Basically red flags that could indicate contamination.
And if they find red flags?
Then you might need a Phase II ESA. That's when they might do soil sampling or test groundwater. But that takes more time, costs more money, and you only do it if the Phase I suggests it's necessary.
Got it. What else on the legal side?
You also do an extensive review of the title. This means digging into the history of ownership to make sure the seller actually owns it free and clear, or at least you understand exactly what limitations exist.
Like limitings or easements.
Precisely. You identify any encumbrances, easements, covenants, restrictions, limits, anything that could affect your ownership rights or limit how you can use the property. You'll get a title commitment from a title company, and your lawyer will scrutinize it and all the underlying documents listed as exceptions.
Exceptions like?
Like maybe a utility company has an easement running right through the middle of the lot, meaning you can't build there. Or there might be restrictive covenants from a previous owner dictating only certain types of businesses are allowed. You need to know all of that. And you also need to confirm that all the necessary permits and certificates of occupancy are actually in place for the current buildings and how they're being used. Plus, depending on where the property is, you might need to research specific local hazards like earthquake faults, flood zones, or maybe nearby sites with known hazardous materials issues.
Wow, that's a lot just on the legal and physical side. What about the money side? Especially for properties that generate income like apartments or shops.
Oh, that's an enormous piece of the puzzle, the financial and operational review. You're going to want to examine the seller's detailed books and records, not just the summary, the real stuff.
Like what?
Income statements, expense reports, the actual rent roll showing who pays what and when, real property tax bills, insurance policies, utility bills, maintenance records, everything.
And if there are tenants?
If there are tenants, you scrutinize the leases incredibly carefully. This is absolutely crucial to verify the seller's claims about cash flow. Are the rents they advertised actually being collected? Are the expenses they reported accurate? Are there weird one-off costs hidden in there? Do any leases have really unfavorable terms for the landlord, or maybe hidden liabilities?
What kind of unfavorable terms?
Things like below-market rents locked in for a long time, unusual tenant improvement allowances you'd have to pay out, maybe restrictive exclusivity clauses that prevent you from leasing to competitors.
Yeah.
You need to know the start dates, end dates, rent increases, everything. You're basically building your own financial model based on the real data, not just their projections, and looking for any red flags or differences.
So you're trying to see if the story matches the numbers.
Exactly. And you're also looking for potential liabilities that might not show up on a simple profit and loss statement. Like, is there pending litigation involving the property? Are there ongoing disputes with tenants that could blow up later?
And sometimes things outside the property lines matter just as much.
Absolutely. External factors can play a huge role. You might research local demographics. Who lives nearby? What's the income level? That matters for retail, for apartments.
Right. Who are your potential customers or tenants?
Exactly. Traffic patterns are vital for retail. Can people easily get in and out? Noise levels, maybe from a nearby highway or factory, could impact desirability. For land you plan to develop, you look into soil conditions, the slope of the land, access to utilities like water and sewer. And like we mentioned with environmental, understanding the broader context. Is it in a liquefaction zone, near industrial pollution? That all feeds into the property's value and risk profile.
Okay, and financing, that's usually happening around the same time, isn't it?
It is. Now, securing your financing commitment isn't always technically part of the definition of the due diligence period itself in the contract.
Yeah.
But it's a critical task that buyers absolutely have to be working on, usually in parallel during this time.
Why?
Because many sellers, especially when the market's fine, just won't accept a purchase agreement that gives the buyer a long financing contingency, extending way past the due diligence deadline. They want certainty sooner.
So you need to get your loan approved quickly.
Pretty much. Getting that firm loan commitment from your lender often requires you to give them all the due diligence reports you're gathering, the PCR, the ESA, the appraisal, the title report. Your lender does their own due diligence too, based on your findings and their own criteria. And their findings can absolutely impact whether you get the loan you need to actually close the deal. So it has to happen concurrently.
So it's this whirlwind of inspections, legal checks, financial audits, external research, and trying to lock down the loan. After all that, what happens? What are the buyer's options based on what they find?
Okay, so based on everything uncovered during due diligence, the buyer usually has a few key paths forward, outlined in the purchase agreement. If the investigation turns up problems, maybe, like we said, a major roof issue nobody mentioned, or an environmental red flag in the phase I, or maybe big discrepancies between the seller's advertised income and the actual lease details.
Then what?
Then the buyer can try to renegotiate the deal. Go back to the seller and say, hey, based on what we actually found, the value here, or the future costs, are different from what we understood when we agreed on the price. We need to adjust the terms. This is often called a retrade.
Asking for a lower price, usually. Or maybe repairs.
Yeah, it could be a price reduction, could be asking the seller for a credit at closing to cover the cost of repairs, or maybe asking the seller to fix specific things before closing.
And what if the seller says no? Or if the problems are just too big to stomach?
If they can't reach a new agreement, or if the issues are just too significant, maybe the environmental cleanup costs are astronomical, or a zoning issue makes the whole plan unworkable, then the buyer typically has the contractual right to just terminate the purchase agreement.
Walk away.
Walk away. That right to terminate is the buyer's main safety net during the due diligence period. It lets them back out without penalty if they're not comfortable moving forward based on what they learned.
And if they do terminate properly within that time frame, what about their deposit, the earnest money?
If the termination is valid and done within the specified due diligence period, the buyer typically gets their earnest money deposit back in full. That money is usually held by a neutral third party, like a title company or an attorney, in escrow precisely for this reason. It's held until the buyer either removes the contingency or the time runs out. If they terminate correctly within the window because they're not satisfied, and often the contract gives them pretty broad discretion there, they get the deposit back.
Okay. What if issues are found, but the buyer still really wants the property, maybe it's a unique location, and the seller just won't budge on price? Is there any other way besides just a price cut?
Yeah, There's another route sometimes, especially in really competitive markets, or if the seller is demanding absolute top dollar and the buyer kind of agrees, it's worth it if these issues can be managed or covered somehow.
Oh,
Instead of a price cut or a seller credit, the buyer might agree to proceed at the original price, but demand stronger seller representations and warranties within the purchase agreement itself.
so the seller makes specific promises about the property.
Exactly. Things like seller represents and warrants that, to their knowledge, there are no environmental conditions requiring remediation, or seller represents all the leases provided are true, correct, and complete copies. And crucially, the buyer might negotiate for a longer survival period for these warranties, meaning the seller remains legally responsible. They're still on the hook if those specific promises turn out to be false for a longer time after the closing happens. So if 6 months after closing you discover the seller did know about an environmental issue they said didn't exist, you might still have recourse against them because that specific warranty survived the closing. It's a way for the buyer to accept a known risk but have some contractual protection if the seller wasn't truthful about it.
Okay, so that covers the why and what of due diligence. It's clearly this deep dive for the buyer. Now let's tackle this phrase you hear all the time, especially in commercial deals. Selling a property as is. It sounds so final, right? Like the seller wipes their hands clean and the buyer takes all the risk. But the sources you looked at suggest that's really, well, a dangerous oversimplification.
It is a critical point. And yeah, it's where a lot of misunderstandings happen and potentially big legal problems can pop up. When a property is sold as is, sometimes they even say as is, where is, the general idea is that the seller is offering it in whatever physical condition it happens to be in when the deal closes.
No promises about condition.
Generally, yeah. It usually means the seller isn't making specific warranties about its condition, and they typically have no intention or obligation to make repairs or give you credits based on what your inspectors find after you've signed the deal. The buyer is essentially signaling, okay, I accept the property with whatever defects might exist that I could find before closing.
So the buyer accepts the risk for the condition, warts and all.
That's the common thinking, yes. But, and this is the absolutely crucial legal point that multiple sources emphasize even with an as-is clause, sellers and their brokers usually still have a legal duty, often under common law, to disclose known material facts, and specifically known latent defects.
Latent defects, meaning hidden ones.
Exactly. Hidden problems that significantly impact the property's value or desirability, and that a buyer wouldn't reasonably discover through a standard inspection. An as-is clause, even in a big commercial deal between supposedly sophisticated parties, generally does not protect a seller from being sued for things like fraud or misrepresentation, and that includes failing to disclose major hidden problems that they knew about.
Okay, and this is where that court case, the S Development Company case, becomes really important to understand this limit, right?
Precisely. The S Development case out of Arizona, which a couple of the law firm sources detailed, is a perfect illustration of how as-is isn't bulletproof. What happened was buyers bought several apartment buildings. After closing, they discovered a huge problem.
What was that?
The buildings were full of polybutylene piping hidden inside the walls. This stuff, sometimes called polypipe, was used a lot in the 80s, maybe early 90s, and it turned out to be really prone to failing, leaking, bursting, especially with hot water. Causes massive water damage.
Okay, so a ticking time bomb in the walls.
Pretty much. And crucially, the plumbing that was visible, like under the sinks, was copper. So the bad stuff was hidden, not obvious at all. Classic latent defect.
So a hidden, potentially catastrophic issue. What did the seller do that got them in trouble despite selling as is?
This was the absolute key fact for the court.
Yes.
The seller knew about the polybutylene pipe. They knew it was there. And during the buyer's due diligence period, the seller specifically refused to let the buyers inspect inside the walls.
Wow. They actively blocked the inspection.
Yes. By preventing access, they essentially stopped the buyer from being able to discover this hidden defect that the seller themselves knew about.
So what did the court decide? Did the as-is clause protect the seller?
No, it didn't. The court found that the seller had a clear duty to disclose this known material latent defect, the bad piping. Because it was buried in the walls, it wasn't reasonably discoverable by a normal inspection, making it latent. And the seller's refusal to allow inspection inside the walls basically turned something that might have been discoverable, if they'd allowed it, into something that was effectively undiscoverable under the circumstances the seller created.
So hiding it and preventing discovery.
Exactly. The court said this failure to disclose, combined with actively hindering the inspection, violated the basic legal principle of good faith and fair dealing that's implied in contracts. Even though it was a commercial deal, even with sophisticated parties, even with the as-is clause, the buyers won big. They got awarded over $3.6 million in damages to cover the cost of repiping the buildings.
Wow. So the huge takeaway here is as is definitely does not mean sellers can hide known major problems.
Absolutely not. As one source put it quite strongly, as is, clauses give sellers zero protection against claims like fraud or misrepresentation, and that includes failing to disclose significant known latent defects that are material, meaning important to the deal. Selling as is doesn't let you off the hook for dealing honestly about major hidden issues you know about that a buyer wouldn't easily find on their own.
So if a seller does know about a big hidden problem when they're selling as is, how can they protect themselves legally and avoid getting sued later?
The sources lay out a clear path for sellers. To avoid liability for a known defect when selling as is, the seller and their broker need to do two key things. First, they absolutely must disclose the known material latent defect in writing to the buyer, clearly upfront in the deal documents.
Tell them about it.
Yes. And second, just as important, they have to make sure the buyer has a reasonable opportunity to conduct a pre-purchase inspection that could allow them to investigate that disclosed defect.
So tell them and let them look.
Exactly. That combination, written disclosure plus the opportunity for inspection, is considered fair dealing. You tell the buyer, look, we know about this issue with the foundation, and you let their engineer come in and assess it. What you can't do is sell as is, know about a major hidden problem, and actively prevent the buyer from finding it. That's concealment. And as is won't protect you from that.
That really reframes the whole as-is concept. It's not just about the buyer needing to look, it's also about the seller needing to be honest about known hidden stuff. It adds a crucial layer of responsibility.
It does. And navigating that interplay, the buyer's duty to inspect diligently and the seller's duty to disclose known latent defects, is really critical for both sides in any commercial deal.
Okay, let's switch gears now to the actual timeline, the due diligence period itself. How long is it? Who decides? Where does all the negotiation and, frankly, the tension around the length come from?
Right. The length and even the start date of the due diligence period are some of the most heavily negotiated items in a commercial purchase agreement, the PSA. First off, the start date isn't always just the day the PSA gets signed.
Oh, when else might it start?
Well, sometimes, as one source noted, the parties might agree it starts earlier. Maybe it's triggered when they sign a letter of intent, an LOI, or even based on the initial offer.
Why do that?
It lets the buyer get a jump start on some things, maybe order the title report early or hire their environmental consultant even before the full complex PSA is totally hammered out. A seller might even suggest this early start as leverage, arguing later for a shorter official period in the PSA because the buyer already had some time.
Okay. And why are sellers usually pushing so hard for a shorter period overall? What's their main motivation there?
It's pretty straightforward from the seller's perspective. They want the deal to go hard as fast as possible.
Go hard, meaning?
Meaning the buyer's contingencies, especially the due diligence one, are either satisfied or waived. And crucially, the buyer's earnest money deposit becomes non-refundable, except maybe in very specific cases like the seller defaulting.
So the buyer can't easily back out anymore, and the seller keeps the deposit if they do.
Exactly. The sooner that happens, the less risk the seller has of the buyer trying to retrade, coming back to ask for a lower price or credits after inspections, or just walking away entirely. If the buyer walks, the seller has to put the property back on the market. They lose time, lose momentum. Sellers crave that certainty in getting control of that non-refundable deposit as early as they possibly can.
Okay, so what's a typical length for this period? 30 days? 60? 90?
It's really all over the map. There's no single standard answer. It's completely negotiated. It depends heavily on how complex the property is, what type of asset it is, office, industrial, retail, land, local market customs play a role, and frankly, just the negotiating power of each side.
So it could be short or long.
Yeah, it could be a relatively short 30 days for, say, a simple vacant warehouse, or it could easily be 60, 90, even 120 days or more for something complex. Maybe a large portfolio of properties, or something needing extensive environmental work or complicated zoning changes, or reviewing dozens of intricate tenant leases.
And how is the time frame defined? Is it just calendar days?
It can be. Often it's defined as a fixed number of calendar days starting from the effective date of the signed purchase agreement. Or sometimes the clock starts ticking only after the seller delivers certain specific agreed-upon documents to the buyer, like the title commitment or maybe existing environmental reports the seller already has.
Triggering it by document delivery sounds fair. The buyer needs the info to start reviewing, but are there downsides to that approach?
Yes, absolutely. One source specifically warned sellers to be really careful with that structure. They should avoid vague language like triggering the clock when the buyer receives all due diligence documents. That's just asking for arguments later. Because what does all mean? Instead, the PSA should list exactly which documents trigger the start date. Specific checklist. And the seller needs to be sure they actually have those documents and can deliver them promptly before they sign the agreement. Otherwise, if a key document is missing or delayed, it creates ambiguity about when the clock actually started, and the buyer might argue they deserve more time.
That makes sense. Be specific. Can different parts of the due diligence have different deadlines within the overall period?
Yes, that's actually a pretty common strategy, especially on complex deals, to try and manage the process and maybe speed things up where possible. Parties might negotiate segmented timelines.
Like how?
For example, you might have a shorter period, maybe just 15 or 30 days, specifically for the buyer to review the title commitment and the property survey. Those items can often be obtained relatively quickly. Then you might have a longer period, say the full 60 or 90 days, for things that just take more time, like completing the Phase I environmental assessment, maybe a Phase II if needed, doing a deep dive into zoning issues, or meticulously auditing all the tenant leases.
So you tackle the quicker stuff first, get potential deal killers off the table early?
Exactly. It lets the buyer identify and address any major title or survey problems quickly, while still giving them the necessary runway for the more time-consuming investigations like environmental or detailed operational reviews.
Okay. What if the buyer is doing everything they can, but they just run out of time? Maybe the phase I takes longer than expected. Can they get an extension?
Extensions are definitely possible, yes. But they're almost always something you have to negotiate with the seller. Sellers are usually pretty reluctant to just grant extensions freely.
Why? Because it keeps their property tied up longer.
Exactly. It keeps their property off the market longer, still with the risk that the buyer might ultimately walk away. So sellers typically want something in return for granting more time.
Like what? More money?
Often, yes. An extension frequently requires the buyer to put up an additional earnest money deposit. And how that extra deposit is treated becomes a key negotiation point.
What do you mean how it's treated?
Well, does that additional deposit just get added to the original deposit? And it's all still refundable if the buyer terminates later and credited to the price if they close. That's what buyers want. Or does that additional deposit become non-refundable to the seller immediately, right when the extension is granted? Kind of like a fee the seller gets to keep just for giving the buyer more time, whether the deal closes or not.
Sellers would push for the non-refundable option, I bet.
Oh, yeah. Sellers love immediately non-refundable money for extensions.
Right.
Buyers, naturally, prefer it stays refundable or at least gets credited to the purchase price. A big point of negotiation.
It really sounds like a constant balancing act of risk and cost for both sides during this whole period. Now, you mentioned earlier that the clock feels like it's moving faster, partly because of current market pressures. What are those specific forces really squeezing the timeline right now?
Right, this trend of sellers pushing for shorter due diligence periods, it seems to be driven mainly by two big factors, according to sources like GlobeSate. The first one is kind of the lingering impact of supply chain issues.
Supply chain. How does that affect real estate due diligence?
You might think it's just about getting goods, but it's had ripple effects everywhere, including the whole ecosystem supporting real estate deals. These issues are hitting the third-party vendors the company's buyers rely on for critical reports.
Which vendors? Like the inspectors and engineers?
Exactly. Surveyors, environmental consultants, engineers doing the property condition reports, appraisers needed for financing, even title companies sometimes. They might be facing staffing shortages, difficulty hiring qualified people, maybe delays getting equipment or accessing certain data if those systems are overloaded.
So the people the buyer needs to hire are slower.
Essentially, yes. It means getting those standard, absolutely critical reports that form the backbone of due diligence, the title commitment, an updated survey, the PCR, the Phase I ESA, maybe a Phase II, the appraisal for the bank. It's just taking longer than it used to in many cases.
Give me an example.
Well, maybe before, you could reliably get a Phase I environmental report back in, say, 2 or 3 weeks. Now, in some busy areas, it might be 4, 5, 6 weeks, maybe even more. Surveyors can be booked solid for weeks or even months out.
Okay, so buyers actually need more time because their own vendors are backed up. But sellers are pushing for less time. That sounds like the core tension right there.
That is exactly the tension. The buyer's practical timeline, the time they actually need to get the work done, is being stretched out by these external delays. But the contractual timeline they're being pressured to agree to is getting shorter and shorter because of market conditions. It creates huge stress for buyers.
And what's the second big factor driving shorter periods? You mentioned market conditions.
Right. The second major cause, often happening at the same time as these vendor delays, is simply hot markets. When a particular sector, like the apartment market was recently, according to one source, or maybe industrial now, gets really hot, lots of demand, not enough properties for sale, it becomes a strong seller's market.
Sellers have the upper hand.
Completely. In those competitive situations, buyers are already having to make major concessions just to get their offer accepted in the first place, sometimes competing against multiple other bidders.
What kind of concessions, besides just paying a higher price?
Oh, buyers might offer much larger earnest money deposits up front. They might agree to make some or all of that deposit non-refundable much earlier in the process, maybe even before due diligence is done, which is risky. They might agree to shorter closing periods after due diligence. They might accept fewer or weaker representations and warranties from the seller about the property's condition or its financials.
Basically giving up protections to win the deal.
Pretty much. And then on top of all that, sellers are using their leverage to demand a shorter due diligence period as yet another key concession. The message is often, if you want this property in this hot market, you need to promise to do your homework really, really fast.
So buyers are caught in this double bind. The vendors they need are slower, making diligence take longer, but the market is demanding they finish faster than ever. That sounds incredibly difficult to manage.
It creates enormous stress for buyers. They know they need to be thorough to protect their investment. They understand the risks. But they're facing real, often unavoidable delays from their own essential service providers, while simultaneously facing intense contractual pressure from sellers to wrap it all up quickly. One source explicitly called out this heightened stress that potential buyers are feeling right now.
Let's dig into that a bit more. What are the really practical, on-the-ground challenges buyers face when they're trying to do good due diligence under these compressed timelines?
Okay, well, beyond just waiting longer for reports from vendors, the sheer logistical challenge of scheduling and coordinating all the necessary inspectors and experts is a huge hurdle, especially for commercial properties, which are often complex.
It's not just one inspection, right?
Right. You might need to line up multiple specialists. You've got your general building inspector, sure, but then maybe a mechanical engineer for the HVAC, a separate roof consultant, maybe a plumber to scope the lines, an electrician, possibly a structural engineer if there are concerns, an elevator mechanic, a fire safety expert.
The list goes on.
It does. Plus, your environmental consultant for the Phase I, maybe zoning attorneys, potentially specialists for things like the parking garage structure or unique building systems. Getting all these different people scheduled, getting them access to the property, often coordinating with existing tenants, doing all that within a tight 30 or maybe 60-day window. It's tough, even in normal times. With short deadlines, it's frantic.
And what happens if one of those initial inspections finds something worrying? That just throws a wrench in the schedule, doesn't it?
It absolutely compounds the problem immediately. Let's say the general inspector notes some signs of water damage near the foundation or sees something odd with a main electrical panel. Now you need to scramble to get a specialist in.
A structural engineer, maybe.
Yeah.
Oh, or a master electrician.
Exactly. You need to schedule them, hope you're available quickly, get them out there, wait for their detailed assessment and report. Or if the Phase I environmental comes back with a recognized environmental condition, maybe you now need to quickly decide if you have time to even attempt a Phase II sampling assessment. Getting those follow-up experts scheduled, getting their work done, and getting their reports back all before your already short deadline expires, it becomes incredibly difficult, sometimes just practically impossible.
Yeah, I can see how that could quickly spiral. The Reddit discussion you mentioned, even though it was about houses, brought up an interesting angle on picking inspectors under pressure. Can you touch on that potential conflict?
Yeah, it's an interesting point, even if it came from the residential side, because it touches on trust and incentives when buyers feel squeezed. The core question raised was, should a buyer automatically trust an inspector recommended by their own real estate agent?
And the potential conflict is?
The potential conflict, as discussed there, stems from the agent's primary financial incentive. Generally, agents earn their commission only when the deal closes. So the concern is, could an agent be consciously or even subconsciously biased towards recommending an inspector who is, maybe, less likely to find huge, deal-killing problems.
A deal maker inspector versus a deal killer?
That was the terminology used, yeah. The fear is that a super thorough inspector, one who digs into every nook and cranny and finds serious issues, might cause the buyer to walk away. That kills the deal, the agent loses the commission, and they have to start all over finding the buyer another property. So the worry is, might they steer clients towards inspectors known for being a bit softer to keep the deal alive?
But surely good agents wouldn't do that. There's a counter-argument, right?
Oh, absolutely.
Uh,
Many reputable agents strongly argue the opposite. They'd say their entire business is built on trust, long-term relationships, and getting referrals. If they recommend an inspector who misses major problems and their client ends up buying a lemon, that destroys their reputation and future business.
so they argue they want thorough inspectors.
They argue they need to recommend thorough, independent inspectors, even if it sometimes means a particular deal falls through. Because protecting their client, building that trust, is ultimately better for their business in the long run. The best advice generally that came out of that discussion, and just common sense, is often to find an inspector through word of mouth from neutral people, friends, family, colleagues who've bought property, maybe even your real estate attorney whose main job is protecting you, not closing the deal.
But the catch is, with a really short due diligence period.
Exactly. With a really tight timeline, your ability to research and schedule that highly recommended independent inspector who might be booked weeks out could be really limited. You might feel forced to go with whoever is available quickly, maybe relying more heavily on recommendations made under pressure.
It sounds like a buyer facing that crunch has to make some tough calls about who to trust and just how deep they can realistically dig in the time allowed.
Precisely. And the risk in making those calls is definitely amplified when the timeline is artificially compressed by market pressures.
Okay, so let's say the inspections get done, maybe with some scrambling. The buyer gets the reports, reviews the financials, the legal stuff. What's their next move while they're still inside that due diligence period?
Right. Once they've gathered all the findings, the good, the bad, the ugly, they have this crucial window to act before the clock runs out on their due diligence contingency. They can take that information and use it as leverage.
To renegotiate.
Yes, to try and renegotiate the terms with the seller. Maybe they go back and ask for that price reduction to cover the cost of the newly discovered roof repairs. Or maybe they ask for a credit at closing for environmental monitoring costs. Or perhaps they ask the seller to fix certain specific electrical issues before the closing date.
Or they can just walk.
Or if the problems are too big, or the seller won't budge on fixing them or adjusting the price, or maybe the buyer just gets cold feet based on everything they learned, and often the contract gives them a fairly broad right based on their satisfaction, they can exercise their right to terminate the contract.
And the huge advantage of terminating within the period.
The absolute critical advantage is getting their deposit back. If they terminate the contract properly, following the rules in the agreement, before that due diligence period officially expires, they could typically walk away clean, no penalty. And that earnest money deposit, which can be a really significant chunk of change in commercial deals, gets returned to them from escrow. It's their safety valve.
What's the big danger if they don't terminate in time? Or maybe the period just expires while they're still trying to figure things out or waiting on one last report?
The deposit risk. That's the primary hammer.
Yeah.
Once that due diligence period officially expires, if the buyer hasn't formally sent a termination notice, and assuming any other contingencies like financing are also cleared, their earnest money deposit usually becomes non-refundable.
It goes hard.
It goes hard. It often gets released from escrow directly to the seller at that point. And if the buyer then fails to close the deal later, for some reason that isn't the seller's fault, they forfeit that entire deposit to the seller. That's the seller's protection against the buyer getting flaky after contingencies expire. It puts immense pressure on the buyer to make a firm go decision within that defined window.
Okay, so buyers have their strategies. Do sellers have specific tactics they use when negotiating the purchase agreement to manage their own risk related to this whole due diligence process?
Oh, absolutely. Sellers, especially savvy ones in strong markets, use several strategies to try and limit the buyer's wiggle room and protect themselves from the deal cratering late in the game. One source outlined quite a few.
Like what?
Well, one tactic, though maybe less common unless the market is incredibly hot, is for the seller to charge a separate, upfront, non-refundable option fee. This isn't the earnest money. It's an extra fee the buyer pays just for the seller agreeing to take the property off the market during the due diligence period.
So the seller gets paid just for letting the buyer look.
Essentially, yes. It's compensation purely for the seller, granting the buyer the exclusive option to purchase and the time to investigate. That fee is usually gone, forfeited to the seller, no matter what happens with the deal later. It shows the buyer is really serious.
What other strategies focus on the terms of the contingency itself?
Sellers might try to tighten the termination right. Instead of letting the buyer walk away based on purely subjective satisfaction, they might negotiate for more objective criteria.
Wow.
For example, the contract might state the buyer can only terminate based on due diligence findings if, say, the estimated cost of necessary repairs identified in the property condition report exceeds a specific negotiated dollar amount, maybe $50,000 or $100,000. This limits the buyer's discretion. If the repairs cost less than the threshold, they can't use that as a reason to terminate. Sellers like objective standards. Buyers prefer maximum flexibility.
Makes sense. And what about extensions? How do sellers manage that risk?
Right, as we touched on, sellers will often build in very clear rules for extensions, usually requiring those additional earnest money deposits. And ideally, from the seller's perspective, they want that additional deposit for the extension to be immediately non-refundable to them as soon as the extension is granted. It's their fee for granting more time.
Well, the buyer wants it credited to the price.
Exactly. That negotiation over how extension deposits are handled, refundable, non-refundable, credited, is a key risk management point for the seller.
Any other ways sellers try to keep leverage during this period?
Yeah, another tactic sellers use is to try and keep their options open. They might continue to talk to or even negotiate with other potential buyers while the primary buyer is doing their due diligence. One source strongly advised sellers not to grant the initial buyer total exclusivity during the diligence period, especially since the buyer isn't fully committed yet and can still walk away.
So they keep backup offers warm.
Exactly. Having backup interest or even a signed backup contract waiting in the wings puts subtle pressure on the first buyer to move forward and protects the seller if that first deal does fall apart. They don't have to start from scratch.
It really is a high-stakes dance, isn't it? Both sides trying to protect themselves while this clock is ticking. Given all these pressures we've talked about, especially on the timeline, is technology stepping up? Is it helping to ease this burden or speed things up?
Absolutely. It's a major trend. Like pretty much every other part of the real estate world, commercial real estate is going through a pretty significant digital transformation. And that trend definitely got a boost from things like the pandemic, which forced more remote work and reliance on digital tools. Technology is increasingly seen as a really crucial tool for navigating the complexities and especially the speed demands of modern due diligence.
How are these new tech platforms specifically helping to make due diligence faster or easier?
Well, according to sources looking at property technology, these emerging platforms are really designed to attack the bottlenecks and inefficiencies in the old way of doing things. They're trying to replace those slow, manual, often paper-heavy workflows that relied on passing spreadsheets around, endless email chains, and fragmented reviews.
Okay, but concretely, how does the tech save time? What does it actually do?
Think about just gathering basic information. Traditionally, you'd have to call different places, email requests for reports, wait for someone to send you a PDF, or even mail a document, then manually combine it all. Tech platforms automate a lot of that. They offer streamlined, much faster access to aggregated property information from various databases.
Faster access.
Yeah. For example, instead of waiting days or weeks for someone to research and write up a basic environmental screening report, some platforms can run rapid environmental risk assessments in literally minutes. They do this by instantly tapping into and analyzing huge databases of environmental records tied to the property's location and history.
Wow, minutes instead of weeks.
It's a huge difference for initial screening. They can also make it much easier to order third-party opinions, things like preliminary property value estimates or zoning compliance checks. What used to involve phone calls and waiting might now be closer to, as one source put it, one press of a button.
So it's taking tasks that were manual and time-consuming and making them almost instant.
For certain aspects, yes. These technologies can provide nearly instantaneous pre-screen assessments on properties. This lets buyers quickly flag major potential deal breakers very early on, before investing a ton of time and money. They can also dramatically speed up the creation of more detailed, comprehensive reports by automating the data collection, analysis, and even formatting that used to take teams of analysts weeks to compile by hand.
And managing the whole process.
Right. They also help create streamlined workflows. Imagine a central, secure digital hub where all the due diligence documents are stored, distributed to the right team members, inspection schedules are tracked, progress is monitored, and final reports are compiled. It's like those old virtual data rooms, but much smarter, often with built-in analysis tools and collaboration features.
So what's the big picture impact of all this tech on the due diligence crunch we've been talking about?
The potential impact is really transformative. By automating the grunt work of data gathering, speeding up report generation, and providing these centralized platforms for review and collaboration, the technology fundamentally saves buyers time and money. It helps them navigate the bottlenecks caused by slow manual processes or even some of those vendor delays we discussed by getting them access to certain types of information much faster.
So it helps them meet those tight deadlines.
It can definitely help. Ultimately, it supports faster-moving transactions, which is absolutely critical in markets where speed gives you a competitive edge. By making due diligence more efficient, companies can potentially screen more deals, react quicker when good opportunities pop up, and move forward with more confidence on the promising ones, or, just as importantly, kill problematic deals faster without wasting weeks and months. Like if you're looking for old warehouses to repurpose, being able to quickly screen dozens of sites for zoning, environmental history, and basic condition using tech, that's a huge advantage.
It really sounds like technology is becoming almost essential for buyers who are trying to meet that seller demand for speed while still doing the thorough review they need to protect their investment.
It certainly seems to be offering a path forward, a way to potentially balance those competing pressures, taking what was historically a very slow, cumbersome, paper-intensive process and making it much more efficient and responsive to today's market realities.
Okay, wow. We have covered a ton of ground in this deep dive. Let's try and synthesize some of the key complexities we've explored today.
Yeah, absolutely. We started off establishing just how fundamentally important due diligence is for any buyer in commercial real estate. It's that critical homework period, right? Where you independently verify everything about the property.
To avoid those nasty surprises, the pig in a poke.
Exactly. And to justify the price you're paying, make sure the property actually fits your needs and plans, all before you're legally bound to close.
And we learned that even that common phrase, as is, isn't some magic shield for sellers. They still have a really important legal duty to disclose known material problems, especially those hidden latent defects.
Right. That S development case was a powerful reminder. Failing to disclose known issues, particularly if you actively try to hide them or block inspection, can lead to serious consequences, huge damages, even with an as-is clause. Fair dealing means you got to tell the buyer what you know and let them look.
Then we got into the timeline itself, how the length is a huge negotiation point, how it doesn't always start neatly when the contract's signed.
And how sellers are laser-focused on getting that deal to go hard, getting the buyer's deposit non-refundable as fast as possible.
Right.
That drives their push for shorter periods and leads to negotiations over things like segmented timelines or how those extra deposits for extensions get treated.
And we spent a good chunk of time on the current pressures really squeezing that timeline. How external factors like lingering supply chain issues are actually making the necessary third-party work surveys, environmental engineering take longer.
While at the exact same time, hot competitive markets are empowering sellers to demand shorter contractual due diligence periods as a condition of accepting an offer. It's a real pincer movement on buyers.
Creating significant stress and practical headaches.
Yeah, we talked about those practical challenges, just the difficulty of scheduling all the different specialists you need in a tight window, the nightmare scenario if an initial inspection finds something requiring more specialized follow-up.
And even the potential complexities around choosing advisors like inspectors when you're under intense time pressure. Plus, always keeping that deposit risk front of mind, knowing when it becomes non-refundable, is critical.
And finally, we looked at how technology is really stepping into this space, trying to be a game changer. Offering ways to automate tasks, get data faster, speed up reports, manage the workflow digitally.
Potentially helping buyers conduct more efficient, faster due diligence, maybe helping them cope with those market demands for speed while still getting the investigation done.
So yeah, the due diligence period remains arguably the single most critical phase for a buyer. It's their chance to truly vet the investment before the money is fully committed. But it's clearly not just a simple checklist. It's this complex interplay of negotiation, legal duties for both sides, diligent investigation, and adapting to market forces and new tech.
It's definitely a high-stakes, intricate process. Information is absolutely power, time is always limited, and the potential cost of missing something significant can be just enormous.
Yeah.
Which kind of leads us to a final provocative thought for you, the listener, to maybe chew on.
Okay.
As market cycles inevitably keep turning, as maybe some of these global impacts like supply chain disruptions linger or morph, and as technology continues its relentless advance, how is that fundamental tension going to evolve? The tension between a buyer's absolute need for thoroughness to protect their investment and a seller's very understandable desire for speed and certainty. How will that balance continue to shift in the commercial real estate due diligence world?
That's a big question.
What new strategies, what new applications of tech, what maybe deeper understandings of legal duties will both buyers and sellers need to master to successfully navigate this essential but clearly increasingly high-stakes phase of a transaction in the years ahead?
It's a really fascinating question. And the answer will definitely shape how deals get done in commercial real estate moving forward.